presiding. All persons business before this court are under your attention, and you shall be heard. May God save the United States of America, the state of Florida, and this honorable court. You may be seated.
Good morning and welcome to a session of oral arguments before the 5th District Court of Appeal. I first would like to introduce to you the panel. On my right is Judge Jacqueline Griffin, and on my left is the Chief Judge of the Ninth Circuit, Judge Belvin Perry, who we've invited over here to sit as an associate judge, and we're always happy to have you sitting with us, Judge. We've got 5 cases on the docket this morning, and the first of which is Michael Joseph MARRA versus State of Florida. Is counsel ready?
Yes, Your Honor.
Do you wish to reserve any time?
Yes, Judge, just a few minutes. 5 minutes. Morning, judges, counsel. May it please the court, I'm Nancy Ryan, representing the appellant Michael MARRA. Mr. MARRA is serving a 15-year sentence with 7 years suspended for a French kiss that was never actually completed. The state relies on the child's direct examination testimony at record pages 1020 and 1021, where the child said that she was tongue-kissed, but when pressed for detail in cross-examination, at the cross-examination leading up to record page 1069, she admitted she never opened her mouth. She explained that while her mouth was closed, this had taken place. Surprisingly enough, French kiss is defined in the case law, in the Altman case, which I've cited from the 4th DCA. A French kiss is a kiss in which the tongue of one partner enters the mouth of the other partner. The state charged a French or tongue kiss, so they've got to prove it, according to this court's decision in DR versus State. There is no such thing as surplusage in the charge of lewd and lascivious conduct. Had this been, say, a murder case, the statement about how the crime took place would have been mere surplusage, but as this court held in DR, the act of touching another person is not in and of itself illegal, so the manner of touching is what determines whether the touching was lewd. So there is no surplusage when the state adds language describing how the touching took place. So our position is that Mr. MARRA's exposure on remand should be no more than 5 years for the offense of attempted lewd and lascivious act. And this case should...
Counsel, there's a supplemental authority that was furnished us by counsel, and it's a very recent Supreme Court decision, State versus Sigler.
Yes, Judge.
And I've gone over that case several times. I'm trying to figure out whether or not this holding in this case, or whether this case would allow us to remand the case for imposition of a finding of guilt on a lesser included offense. What's your view on that?
I think Sigler is distinguishable because in Sigler, the defendant was charged. You know, the defendant was charged with first-degree felony murder with the underlying felony of escape, and the district court reversed his second-degree murder conviction and imposed a third-degree felony murder conviction with the underlying charge of harboring an escaped prisoner, which had never been charged. But attempt doesn't need to be charged. So here you wouldn't be interpolating an element that the jury never had a chance to consider.
Well, would we be within our rights as an appellate court to remand this for imposition of a finding of guilt on the lesser included offense of attempt? Where I'm coming from is this. As I read this record and the evidence in the case, it looks to me like there was an attempt to commit lewd and lascivious behavior rather than an actual successful completion of that. And it's because of the way the state charged this defendant with French kissing, or I forget how but the wording of it really kind of created a problem for everybody in this case, I think. But are we within our rights to do that?
I believe so. I believe Sigler is distinguishable. If not, the case does need to go back for a new trial, and the jury at that point would have a chance to consider the offense of attempt.
Well, why can't, rather than a whole new trial, why can't we just direct the trial judge to enter a judgment or a conviction on the lesser included offense of attempt?
Because of the other errors which took place at the trial. First and foremost, the jury selection issue regarding...
Let's assume there are no other errors as a hypothetical. I understand your argument, but let's assume there are no other arguments, and that's the only issue that we've got to deal with. Can we do that?
I believe you can distinguish Sigler and do that, yes, Your Honor, under 924.33.
Okay.
So you're saying, my reading of the Sigler case is that the jury, in making their findings, must necessarily find all the elements of the lesser included offense in order for the court to go back and direct that they be found guilty of that particular lesser included offense. So you're saying that all those elements that the jury found are also found here for the lesser included offense?
Yes, Judge, because an attempt is deemed charged in every completed offense under the, I believe it's the Roby case from the Florida Supreme Court in the somewhat distant past.
Tell us about these other errors and that you...
I'd like to jump down to point 6, which would have been point 1 had the Copshow v. State case been decided at the time I wrote the initial brief. The problem here is that Venari member Foley was never rehabilitated after he expressed strong doubts about his ability to overcome his hesitation in reaching a verdict where the defendant did not testify. In the Copshow case from the Florida Supreme Court, which was decided during the briefing, there was a Venari member who was only equivocal about his views on the defendant testifying, and the Supreme Court in that, Florida Supreme Court in that case reversed the capital conviction based solely on that ground. And I submit to you this case is even stronger because Mr. Foley was unequivocal. He was not rehabilitated. What he said was, the last thing he said was, I would have a problem with that. Another issue for remand is the jury instruction regarding the testimony of the alleged victim. The state asked for and received a non-standard jury instruction to the effect, or specifically saying that the testimony of the victim need not be corroborated in a case of this nature. That language is that of section 794.022 of the statutes, but again, it's not a standard jury instruction. Our position is that to comment on the evidence, just as much as the old proscribed jury instruction back is sort of the flip side of this instruction. Back before 1974, the juries were instructed that the testimony of the prosecutrix in a rape case must be rigidly scrutinized. That was struck down by Florida's appellate courts as being a comment on the evidence. It seems to me this is just the flip side of that, and this instruction is just as toxically a comment.
Let me go back to your unrehabilitated juror point. There's a couple of cases, Caratelli and Copshow specifically, which seem to hold that the defendant has to prove that he was prejudiced by that juror. And to demonstrate prejudice, he's got to show that he's exhausted all of his remaining preemptory challenges and that an objectionable juror has served on the jury. And I don't know, did he make any, or did the defendant make any showing that all of his preemptory challenges have been used up?
Yes, Judge. This is at trial transcript pages starting at 704 and ending up about 710. The point was perfectly preserved.
And he actually sat on the jury. Yeah.
I'm not sure if he sat on the jury or if they had to use a peremptory on him. I think they had to use a peremptory on him, but identified another objectionable juror as sitting on the jury.
Well, if let's assume he's unrehabilitated, but they exercise a preempt and he doesn't sit on the jury, how has your client been prejudiced?
The case law presumes that he's been prejudiced if another, in Florida, the Florida goes farther than the federal courts. Your question would be well taken under the federal law, Ross versus Oklahoma, but under the Florida case law, Trotter versus State, the defense needs show only that an objectionable juror was identified after all peremptories were exercised, after more peremptories were asked for.
Which objectionable juror was identified?
I'm sorry, Judge, I don't recall.
But you're sure that one specifically was identified?
I believe so, Judge. As I recall the record, the point was
that would be in those pages you just cited to me?
704 through 711.
Okay.
And I've got a third trial issue I'd like to discuss this morning, and that's the prosecutor's comments. I'm relying on this court's decision and opinion in Sempier versus State. That's at 907 Southern 2nd, 1277. That case precludes statements of personal belief in the defendant's guilt made by the prosecutor. That happened in this case, and it was objected to at record page 2125. The state said, the kid said he did it, the defendant did it. Under Sempier, that's an impermissible comment. That was found fundamental error in Sempier. Here it was objected to. Again, in this case, you've got the prosecutor saying something that was that's precluded by Sempier. She argued, if you believe the victims, then the defendant is guilty. There was no objection to that, but that was found fundamental error in the Sempier case. Here, that's an improper instruction because it takes away all elements of the crime from the jury. Here, in this case, if they believe the child and then their deliberations were at an end, then they'd never reach the intent question, whether the act was intended to be lewd. So we've got prejudicial error here. That's, I'd like to reserve my remaining time for rebuttal. Thank you.
May it please the court, my name is Bridget Collins and I represent the state in this appeal. To go back to some of counsel's arguments, beginning with the cop show case and the impanelment of the jury, it's the state's position that there is no reflection in the record of MARRA or counsel identifying an objectionable juror that served on this jury. What the record does reflect is that counsel stated that she objected to the panel, that she wanted to use, that she objected because she was not allowed the cause challenge for Foley and Contine, and then that she was objecting to the panel. She did not specify a juror who was going to be seated or was in fact seated on the panel that she objected to. As to counsel's second argument regarding this issue number 5, which was the jury instruction. Just 1 second so I can get to it. It's essentially a moot point, as that instruction specifically only was instructed on count 1, the count that Mr. MARRA was found not guilty of. There was no bleed over into any of the other counts. It was specific to count 1, and Mr. MARRA can establish no prejudice when he was found not guilty of that count. As to counsel's third argument with regard to closing argument of the state, counsel said that the prosecutor's comments were improper and prejudicial. Relying on Sempier, Sempier can be distinguished from the case at bar in that in Sempier, the counsel had said, when you look at all of this testimony in the case, there may be conflicts, but the bottom line is, if you believe her, the victim's testimony, that's all you need. That's not what occurred in this case. In this case, the counsel said, if you believe the victim beyond a reasonable doubt, that is not, in Sempier, that the counsel took reasonable doubt away from the jury. In the case at bar, reasonable doubt was still, the counsel instructed that the jury needed to still find beyond a reasonable doubt that Mr. MARRA was guilty.
Counsel, what's your take on the Sigler case that you filed supplemental authority on?
On the Sigler case...
You've stated in your notice that it... well, the language of it, let's see. If the appellate court determines that the evidence does not prove the offense, but does establish a lesser statutory degree, the appellate court shall, like it was almost an obligation, reverse the judgment and direct the trial court to enter judgment for a lesser degree of the offense.
Yes, Judge. That is what the Sigler case does say. The state's position, however, is still that the testimony at trial by this child victim was that Mr. MARRA French kissed me. I think her statement was that he tongue kissed me and got a little saliva in my mouth. That is not an exact quote, but that is what she said, that there was French kissing and that saliva got into her mouth. Now, while pressed for details in front of the jury... Was there an instruction by the court that defined French kissing? I do not believe so.
And that's what he was charged with. Well, that's what the information...
Correct. The jury instruction said that the state must prove the following two elements beyond a reasonable doubt: that the victim was under 16 and that the defendant intentionally touched the victim in a lewd or lascivious manner.
So do I understand your answer to be then that the state concedes that tongue kissing and French kissing are the same thing?
Yes.
Okay.
Yes, and the victim, while on direct examination, specifically testified that the defendant did, in fact, French kiss or tongue kiss her. I don't recall what the victim...
The testimony is not very clear in my view. I've read it several times, and it appears to me like it was more an attempt, but it didn't succeed because all he did was kiss her on the cheek. There may have been a little spittle that had gotten on her, but as far as tongue-to-tongue contact, there's nothing in her testimony that substantiates that.
Correct, Judge. There is nothing that the victim said that his tongue touched my tongue. What the victim did say was that he French kissed or tongue kissed me. Again, I apologize. I don't know her exact words. And it's the state's position that that's enough to overcome the burden for overcoming a judgment for a JOA.
But did the victim testify as to what she thought tongue kissing or French kissing was?
No, I don't believe she did. No, but...
So we're left to speculate as to her definition of French kissing and tongue kissing. When you have the more specific testimony of actually what actually occurred during the kiss.
No, there's no specific testimony about what exactly occurred, just her understanding, the victim's understanding of what occurred. Are there any further questions? If there are no other questions, the state would request that this court affirm the rulings by the trial court and uphold the guilty verdict for Mr. Marra. Thank you.
Judges, on the jury instruction point, Ms. Collins may be correct that there was no objection to a specific juror. I'm sorry, I don't know. I should know. If she's correct, then that does spoil my perfect preservation argument. As to the jury instruction on the testimony of the alleged victim, the only defense to that argument that the state has made is that that instruction was given only as to count one, where the jury returned a judgment of a verdict of not guilty. I submit that's not a very good argument because, I mean, as we sit here, we're all very familiar with the distinction between Chapter 794 and 800. We know what the elements are. We know what the defenses, the possible defenses are. But the jury's in no such position. I mean, they heard that the testimony of a victim need not be corroborated in cases of this nature. And I submit that was a toxic instruction and that it doesn't help that it was only given on the one count. I believe that as to the prosecutorial comments, the Sempier case is not, in fact, distinguishable. I don't believe the difference in the language of the comments made by the prosecutor is distinguishable on any principled basis. Sempier was a weak case, but there's no distinction here because this was a weak case too. The jury asked for a readback of A.S.'s testimony. They asked to hear and did hear all the audio tapes again, the defendants and both the little girl's audio tapes. So I'd submit that Sempier is indistinguishable and that this court should remand not only for limited exposure of 5 years on the third-degree felony, but for a new trial altogether. Thank you.
Thank you, counsel.